So, ayun guys, good morning again. I am Ariel Villanueva, BS Criminology 2-2 from Isabela State University. I am from Ramon, Isabela. So, ang gagawin natin today is itatackle natin yung dalawang topic ko today, which is the photographic evidence in the court and testifying in the court. So, bali dalawa yung topic ko ngayon. Pero ang unahin nating i-discuss o pag-usapan ngayon is paano ba tayo mag-present ng photo in the court na as a evidence. So remember guys, the recommended size of photograph in the court is 5x7 or 8x10 or bigger. Yun yung legal size ng photograph na kailangan nating ibigay dun sa court. At yun yung gagamitin nating evidence. So, there are three major qualifications of photograph in the court. First is, object pictured must be material or relevant to the point in issue. So, the photo must be an evidence if it is connected to the issue being investigated. Presenting a photo must always relevant. So, for example, yung asawa mo o yung partner mo o kung sino man, nakikalabit siya sa iba, tas nakita mo. So, pipicturean mo siya. Dapat full detailed, clear yung pag-take mo ng photo sa kanila para kapani-paniwala yung i-represent ng photo evidence in the court. Ganun yun. So, pangalawang major qualification is the photograph must not appeal to emotion or tend to prejudice the court or jury. So, photo presented on the issue is for evidence. Not because you like the background, the ambience, the location, etc. or what. Remember, the photo as an evidence should be precise and detailed. Dapat detalyado yung i-represent mong photograph doon sa court. Dapat hindi siya blur, hindi nakatalikod yung dalawa. Kung yung i-present mong photograph is nakatalikod, so sila ba yun? Pwedeng magkahawig lang sila. So dapat kita yung mukha nila na sila yun. Ang patlong major qualification guys is the photograph must be free from distortion and that misrepresent the scene or the object it purports the reproduce. Or hindi siya na-reproduce, hindi siya nasira, hindi na-edit, basta yung hindi siya blurred, dapat cleared siya. So in this situation guys, investigation or the investigation from the scene, kung sino man yung humahawak ng kaso, kung sino man yung naka-assign doon, dapat hindi siya bias doon. Dapat kung ano yung nasa batas, yun yung sundin. In this situation, investigation from the collected photos or videos must be from any bias. Dapat fair, dapat equal, dapat walang bias ang pag-investigate or kung sino man yung naka-assign doon, kung sino man yung mahawak ng kaso doon, dapat fair and equal yung labanan. Ganun yun. So, punta naman tayo dun sa pangalawa nating topic, testifying in the court. So, paano nga ba? Paano ba sisimulan? So, hindi ko rin alam kasi hindi ko pa na-try mag-witness sa court. So, one day, baka
ikaw, ako, sila, o baka tayo
ang magbibigay ng testimony sa isang krimen na tayo mismo ang nakita. Siyempre tayo din yung mapupunta sa court at mag-witness. So, ganun yun. So ganito. First, always consider ourselves to be a neutral witness. So, dapat kung ikaw ang mag-witness, dapat neutral ka. Wala kang papanigan, wala kang ipagtatanggol. Bagkos sabihin yung katotohanan. Magsabi ng katotohanan. Kung kaibigan mo man siya, kamag-anak, o kung sino man siya sa buhay mo, kapamilya mo, gano'n, dapat wala kang papanigan. Sabihin mo yung nalalaman mo, yung nakita mo. I-present mo lang. Show to the court. Ano pang silbi ng pagpunta mo doon sa court kung hindi ka naman magsasabi ng totoo, kung puro kasinungalingan lang naman yung sasabihin mo doon. So dapat sabihin mo yung katotohanan, tell the truth kasi baka ikaw pa yung mapahamak. So If the law has made you a witness, remain a man of science. You have no victim to avenge, no guilty or innocent person to ruin or save. You must be witness within the limit of science. Mag-witness ka within the limit of science. Wala kang ipagtatanggol, wala kang isasalba, wala kang kakampihan, wala kang ilalaglag. Dapat equal, dapat fair. Ganun dapat. Ganun yun.
Hi, my name is Plinky Sanchez. So my topic is tips to be observed during court appearances. So number 1, dress properly and appropriately when going to court. Formal attire like barong Filipino or long sleeve with a necktie is highly advised. Wear your uniform if you have one. So, ang pagdadamit ng maayos sa loob ng korte ay isang karespeto at magandang bagay. At isa yon sa mga etiquette na kailangang sundin pagdating sa courtroom. So, number 2, when your name is called for the witness stand, rise and walk with normal strides. Remain standingly until you are sworn and then wait for the instruction to sit down. So, kapag tinawag ka, kailangan mo tumayo at hintayin mo yung instruction na paupuin ka. So, yun yun. Number 3. Upon sitting down, maintain comfortable, relaxed but dignified posture. Do not slouch. Sit straight and avoid crossing your legs, and your arms should rest normally on your laps. So, kapag nakaupo ka, kailangan mong umupo parang isang nasa training ng military. Dahil yun yung isa ring etiquette sa loob ng courtroom. Kailangan mong umupo sa naayon at hindi kasi maganda tignan kung atas yung isa mong paa, tapos yung kamay mo nasa likod kaganyan. Then, dapat umupo na maayos. Then, alam naman natin kapag first time mo sa loob ng courtroom is nakakakaba talaga. Kasi, lalo na kapag witness ka at sasabihin mo yung dapat. Well, naranasan ko rin kasi yan sa loob ng courtroom. Nandun lang naman hindi ako na nanonood sa mga nangyayari. Pero kaya mo yun, kung kaya mong kontrolin yun by doing inhale or exhale, or you must avoiding contact eye with the lawyers or the person in front of the courtroom that will affect your self-confidence. Number 4, show your respect to everyone by addressing the lawyer, sir, and the judge, your honor. Example sa judge, yung yes, your honor, and no, your honor. And number 5, speak in a clear and distinct voice, loud enough to be heard by the judge, the lawyer, and the people of the courtroom or the gallery. So, kapag nagsalita ka, kailangang malinaw at malakas para marinig ng judge, ng lawyer, at ng mga taong nasa loob ng korte. Para mas maintindihan at marinig nila yung sinasabi mo. Hindi kasi maganda kapag nagsasalita ka tapos mahina. Ano yun? So, kailangang malakas talaga. Hindi man as in malakas. Enough na para marinig ng mga taong nasa loob ng korte. Number 1, The lawyer and the court will see to it that the case is properly developed. Preliminary questions are usually asked first before questions on the issue of a case. Number 2. Questions which require a plain yes or no answered must be done. Answer question directly and completely, but do not volunteer additionally information unless it is necessary. Number 3. Before answering the question, be sure that you understand it clearly. If not, politely request for a clarification if you feel or think that your answer to a certain question may give the lawyer or the court an erroneous or wrong impression. You must immediately ask for permission to amplify or explain further his reply to a question. So that's my topic, and then, well, courtroom must be treated as a formal place, and because it is not a break, lunch, or office, or living room, and it should not treated as such, because courtroom is deserve respect. Kahit pa room lang yun. So, andun na nga court. Kailangan respetuhin yung courtroom dahil doon nangyayari yung mga bagay na dapat at respeto talaga lang. And that's my explanation. Thank you.
Hello, I'm Charlene Vecente, IBS Criminology 2-2. So this video is the continuation of our topic given to us entitled Tips to be Observed During Court's Appearances. So, number 4, if the answer to a question requires that you consult your notes, also ask the permission of the court to do so. Be prepared to submit said notes if the court so require. Number 5, if a question asked in regard to the relevancy of or materiality of the photograph being submitted in evidence, courteously state that you are leaving said issue to your lawyers. When confronted by a question whether you consider yourself an expert or not, your response should be that you leave it to the discretion of the Honorable Court. Any attempt on the part of the witness to claim or represent himself as an expert may allow the opposing lawyer to ask questions on the extreme technical subjects like physics or light, or on the chemical components and reactions during chemical processing. If you are confident, however, that your knowledge on the subject is sufficient, then you don't have to worry about it. Avoid the use of harsh or vulgar words during testimony. It does not only demean the personality of character of the witness but also honor and prestige of the organization whom he represents. Some lawyers, in their desire to confuse or excite a witness, may ask a very personal or insulting question or remarks under such circumstances. Show your professionalism and earn the respect of the lawyer in the court by not arguing with him on the matter. 14. At the end of your testimony, polite ask for an excuse from the judge before standing. Leave the witness stand with appearance of dignity and pride. And last, try to remember the word of the famous trial lawyer. If you know the facts, then you are ready for trial. So that's it.
good morning, sir. My report is all about the admissibility of digital photograph in court. So, kailan nga ba kinoconsider ang digital imaging sa law enforcement? So, it says here that the concern of the admissibility of digital photographic evidence in court is often raised. So, meron kasi mga instances na ang digital imaging is tinatanggap sa korte. Wherein, yung digital photograph is easily altered. Meaning to say, mabilis siyang mabura ganun. While dun sa film-based photograph is, yun yung palaging tinitingnan. Or, it is usually cited. So, merong mga expert na sinasabi na ang digital photograph is not admissible or allowable in court. So, what is about photograph? So, photograph, it is a product of photography. So, meron tayong mga principal requirement para ma-admit na yung evidence is digital photograph or film-based. Meron, isa dito yung relevance. Meaning to say, masatisfy mo yung needs ng korte and also the authentication to be able to admit or allowable. So, dun sa pag-admit ng both parties, ang tawag dito, yung evidence dapat is naka-prepared as a testimony. Halimbawa, kung ano yung nakita ng witness dun sa crime scene is pareho or match dun sa na-captured na image. So, meron tayong mga guidelines para ma-ensure yung digital photograph are admissible. So, yung first guidelines is that the SOP should include when digital imaging is used, chain of custody, image security, image enhancement, and release and availability of digital images. So, dapat yung SOP is may pagkakaisa or chain of custody. Then, dapat yung image is secured. Then, and also the SOP should not apply just to digital but should also include film-based and video application as well. So, dapat pag kukuha ng image is hindi basta digital lang, kundi ginamitan din siya ng film-based and video application. So, the most importantly is that yung image is dapat na preserve sa original na image nito. So, meron tayong mga variety ways para mag-save ng file. Pwede kang gumamit ng hard drive or CD as well. So, meron din mga eksperto na ang usually na ginagamit nila is image security software. So, yung pang-apat na guidelines is like what I said a while back, yung digital images should be preserved. Dapat yung pinaglagyan ng image is secured siya or nandun yung original format niya. Ganun, para maiwasan yung lossy compression. Lossy compression meaning to say yung pwede siyang mabawasan or pwede siyang madagdagan. So, after na-analyze yung images, dapat nakalagay siya sa bagong files, pero hindi siya nabawasan and also hindi siya nakulangan. Nandun pa rin yung original file format. That's all.
Hi, I'm Charlene Valerio, BS Criminology 2-2 from Isabela State University Main Campus. Washington of State versus Eric Hayden, 1995. In the Washington State versus Eric Hayden case 1995, the defense objected to the digital photographs being admitted into evidence. Because Hayden said that the photographs were manipulated, a Kelly Fryer hearing was held and the court authorized the use of the digital photographs. Hayden was found guilty and filed for appeal 3 years later. Here in this case, we will find out if the digital photographs that were used in Hayden's case were really manipulated as he said. In presenting digital photos as evidence, the use of digital imaging technology raises serious questions about where enhancement ends and manipulation of evidence to fit police needs begin. Also, the court held the scientific evidence is admissible only if it meets certain criteria, such as being testable, having a known or projected error rate, having been subjected to peer review and publication, and having achieved a level of general acceptance in relevant scientific community. For police and prosecutors, the use of digital enhanced evidence is non-issue. They say the enhancement process adds nothing to underlying image. It only makes what is already there more usable by improving sharpness and image contrast. They argue a fingerprint is too complex to be altered digitally, and besides, they say the software they use to enhance the image would prevent them from altering it even if law officer wanted to. But for some defense, attorneys and experts of scientific evidence, the use of digital imaging technology raises serious questions about where enhancement ends the manipulation of evidence to fit police needs begin. If the both parties' lawyers are presenting evidences, they should make sure that the images gathered as evidence must be prepared to offer testimony that the photographs are inaccurate. Representation of the crime scene, it also means that someone must testify that the photographs accurately portrays the scene as viewed by the witness. Digital photograph enhanced is not new in some experts. It is because if you're enhancing the photographs, all you're doing is muting the background and you're not changing the original image in any way. The court also have generally been receptive to the use of digitally enhanced photographs as long as the proponent of the evidence has made a proper showing the reliability of the technology. In some cases, judges also have even ordered the photographs be enhanced to improve the quality of an image prior to trial. Also, the more police find ways to use digital enhancement, the more defense lawyers will find ways to contest its admissibility, and now that the technology is relatively widespread use, there will likely be many more battles to come. The lawyer of Eric Hayden will somehow tell you that by enhancing what's there, you've also altered it in some way. And also, they will tell the judge that how they will supposed to know that what they're looking at is really an accurate depiction of what found at the crime scene and not something that came out of the mind of the enhancer. the State of California, the case of State versus Philip Lee Jackson, 1995, digital image processing was used to process a latent fingerprint found in a double homicide case. The San Diego Police Department had been using the technology and had never been questioned on its validity. However, in this case, the defense asked for a Kelly Fry hearing. The court ruled that a Kelly Fry hearing was unnecessary on the argument that digital processing is a readily accepted practice in forensic and that new information was not added to the image. Even though digital photography has been upheld within a courtroom, it does not mean that there is a chance that it could be found admissible.